Morning, everyone. Good morning. My name is Anthony Amaral. I am the chair for the Kent Washington Association of Realtor Education Board. We are a committee formed in order to provide useful information to our membership on a monthly basis. Today, we have a presentation.
Do I have a website? Yeah, I do. I don't use
You asked everybody to use their microphones.
Not really starting, but they just opened it up. But I'll talk after. Okay. Okay.
We need a universal muting.
We do.
I'm gonna mute everybody.
Thank you, Linda. Brian LaPlante is a principal of the firm LaPlante, Sauer and Goldman. He has
Oh, I have to unmute Anthony.
Hi, everybody.
Got it. All right, start over. Brian LaPlante is the principal of his firm, LaPlante, Sauer and Goldman. He has decades of experience in complex business and real estate law, including contracts, purchase, sales agreements, leasing, condominium issues, zoning and land use, litigation and construction. He has served as the Kent Washington Association of Realtors legal counsel for many years. And this morning, he's going to be discussing the updated purchase and sales agreements for the October of 2020 revision that was presented. Brian, go ahead.
Thank you, Anthony. If everyone could please kindly just mute your microphones right now. I'll entertain questions after, and I'm happy to do so. If you want to communicate, I think that there's a way for you to, perhaps raise your hand, or you can actually just raise your hand on your video. If you want to interrupt me, that's fine. I want this to be interactive and informative. So I have, for several years, taught classes concerning the purchase and sales agreement with which you all operate. And ultimately, your objective in your businesses, respectively, are to consummate deals. And there's nothing more important to that business objective than actually preparing and having signed a purchase and sales agreement. It leads to a closing, which leads to you making money, ultimately, your objective. I think that this document in particular is incredibly important to you, because although the quality and success of your business is dependent upon personality and timeliness of communication, the manner in which you communicate, your ability to add value to the sales process, this document is one of the primary tools with which you have to operate. And I can tell you that it's very rare when I teach these seminars that the folks that are in attendance, the participants, have ever read cover to cover this tool of trade, the most vital tool in your toolbox. And I'd recommend, frankly, that you do. And I do it not because I want you to become a lawyer, or I want you to become a scrutinizer of information. I say it because I think your familiarity with it and understanding of it will allow you to provide better service and to do your job better and to get to more closing tables. It's just a fact. And I think knowledge is power. It's why Linda asked me to teach this seminar. I'm going to focus in particular on changes that were made with the October 2020 revision. And I think that there's a lot more to teach about the agreement itself. If I have time, there are a couple of points I'm going to make. I call them extra points, for your having spent some time with me. But this is going to be really short and sweet and to the point. I hope to bring some flavor to this that is hopefully a little bit different than you've thought about and learned in the past. I do a lot of closing work. And so I certainly have experience with the document and with commercial, purchase and sales agreements. as well. But I also do a lot of litigation, and that litigation has allowed me to perceive the process a little bit differently than a lot of other lawyers and people. I've seen disputes and how the court views certain things surrounding this document. So let me get into it, and I'm going to go through and essentially focus again on the changes that were made in this latest version. And I'll say something initially too that I need you all to contextually understand it. In Commonwealth of Massachusetts, nearly every deal, I should say, is initially prepared in connection with an offer process and handed off to a set of lawyers who negotiate and finalize a fairly complex purchase and sales agreement. They utilize form documents. There's no question about that, but they very much customize there, and the lawyers are deeply involved in that process. And you don't have that same practice here. And I think it's healthy in some respect because you don't get bogged down, lawyers who need to pay, but at the same time puts some pressure or that the I's are dotted and crossed. Another reason why I think your familiarity with the document and carefulness associated with this process is really important. You're handling the most important transaction that most people will involve themselves in during their lifetimes. And so I think that backdrop is relevant. I also want to say this, to the extent that you need to vary from the form document, which is intended to be fair to all parties, if you do so in any kind of substantial material way, if you start writing in a lot of additional provisions, I strongly recommend that you consider getting involved. It can be dangerous, held to the standard lawyer at that point because you're engaging in lawyering. And I say it not because lawyers are somehow special, but I want you to just protect yourselves. And so there are a lot of lawyers out there that can turn these things fairly quickly so that they don't interrupt your business flow. So just food for thought. Let's get into section 2. So section 2 was changed, and it concerns the date that's deemed to be the date of the agreement. And this is something with which we all deal, in the past, trying to count days. When do the 10 days start? When do the 14 start? There used to be, an identification of the date of the document. Then there was a flow to the date of the last signatory to the document. And the important thing for you to know here is that, as I have in bullet point number 2, it's delivery, right? The delivery of the document is the trigger for the counting of days. And that's actually appropriate. If you think about it, if the seller signs and the buyer countersigns on a Sunday, the Sunday the 10th, but doesn't deliver it to the seller until the 12th, there could be, there are counting issues associated with that, and frankly, lost time. And it's not fair. And that's especially true for the buyer. The buyer who has requirements for inspection and other issues could lose time simply by the retention of the signed document by the seller. So the new document is triggered for time measurement by the delivery. Now, delivery, it's important for you to know, includes not only direct delivery to the buyer or seller, it also includes the licensees. So if there's an exchange of communication and signed documents between the buyer and, let's say, the listing licensee, that's sufficient to trigger the delivery as long as that document's fully signed at that point. The other thing is email. You have recognition in section 18 of your purchase and sales agreement that email is effective communication. It's effective delivery. And so to the extent that a listing licensee emails a fully signed document on Sunday the 10th, that is the trigger, Sunday the 10th. It doesn't start on the next business day or something to the effect of, of any change from that actual delivery date. The other thing I want to talk about is day. I get this question a lot. What does day mean? Does it mean end of business? And the answer is there's nothing in the agreement that suggests it's end of business day. And so if a licensee sends a document on Monday evening, the 11th of the month at 11 p.m., then the next day is Tuesday the 12th. That's the first day that we count for the various requirements under the agreement. I really think it's prudent for you as licensees to, when you get that fully signed agreement and you recognize that trigger date, the delivery date of the fully signed deal, to chart out when those due dates are, because they're kind of buried throughout the document. You have these various counting pieces, components, like for inspection, and other pieces like that. So I just think it's prudent practice to do that. Any questions about this section? We can kind of go section by section like that. Any questions? Linda, is there a way for you to see if they have questions? Notwithstanding they're being muted?
Well, they could put them in the chat if they wanted to, or they could just unmute themselves and ask the question. What would you prefer?
Yeah, I mean, I think unmuting themselves, but if you master muted them, they may not have that power.
Oh, they can. I believe all they have to do is unmute.
Anthony, can you test that, please?
That's the mute. All you have to do is unmute. You can actually hold the space bar down if you want to talk directly to as well. And when you release it, it should go back to mute. The shortcut.
Excellent, excellent. So yeah, anybody have any questions on this section 2, the new language about delivery date? Okay, great. I'll move on. Section 3. Section 3 concerns the provision of deposits. And I guess that was an issue. Again, the purpose of these changes were to address what RIAR perceived to be recurring issues practically that licensees were contending with. And so it makes sense that they did their best to address these issues. So when it comes to deposits, there was often a lag in the representation that was made in the prior form. And I recall it for, I think, years, it said this, that the X dollars, okay, was to be paid on or before at the time of the executed agreement, is typically what people would write in, but it wasn't practically true. The dollars were not delivered. So someone would send over, for example, on a Monday evening, a fully signed agreement, dated that Monday the 11th, but the dollars from the buyer wouldn't flow for the deposit until Tuesday or Wednesday or Thursday, and that was an inconsistency. And so what they did here is they instead allowed for a time period within which that deposit has to be provided. Okay, so that's on that first line of the breakdown of the purchase price. Now, curiously, they used the word hours. I found that to be a little bit curious because I don't really know what it means. I guess if tested, so for example, let's take an example. Monday the 11th at 11 p.m., the seller sends this back and the seller writes in, I want that deposit within 8 hours. Or more appropriately, 12 hours. I want it within 12 hours. Well, I guess the timestamp would be with email, right? If they send it at 11 p.m., it would be within that time period measured from the email. What if, I make a note here, what if it was sent by mail? Because that's an acceptable form. So the use of the word hours, I just caution you to think about it. I think the intent is really to say 24, 48. The idea is to do it in days, but I think maybe they wanted to give you flexibility to really demand it that next business day, for example. And so, that's basically what that provides. And then lastly, they removed from the manner in which the dollars are paid, both at closing and for the deposit, they removed cash. And because I guess the dangerousness issues of lawyers or brokers holding cash, they removed that piece from the permissible types of deposits. Any questions on this section 3, new style?
Sorry, I do have a question, Richard. I'm driving, so I don't have my video on.
Yeah.
But I'm a new agent, so I got licensed right around the change. The clarification that I'm looking for is if we add in 48 hours, what is the difference between the 48 hours and the provision of time is of the essence?
Yeah. So let me go back to that. That's actually a huge.
Sorry, I was in the tunnel in Boston when you.
Yeah,
in that section.
That's a huge piece of that, and I moved past it. Time is of the essence. So let's talk about that. So the first thing is that I want you to know what Rhode Island law is generally when time is not identified as being of the essence. So the Rhode Island Supreme Court has spoken to this several times, and essentially what they've allowed for is a reasonable time, something that's customary and reasonable. And so an example would be if we had if you can just mute your phones, that'd be. So
Right.
yeah, I'm good.
Okay.
So basically it would be a reasonable time period. What does that mean? I don't know. It really depends upon what a jury would say. But generally speaking, we all understood it to be within days, maybe a week, a month, much too long, right? Reasonableness, an industry standard. What checking off time is of the essence does is it becomes what I said here in this first note, a railway timetable. It is enforceable literally to the hour. It means that the parties have agreed that they're not going to allow any latitude for custom or just for reasonableness. It's going to be a railway timetable. And what it does is it puts the pressure on the buyer to step up and provide the dollars in support of the agreement. And barring that, the seller can drop out of the deal. So if, for example, let's play this out, the seller checks off time is of the essence and says, I want the deposit within 48 hours. They send the agreement out at noon on Monday. It means they want the deposit in hand, in the escrow agent's hands, by noon on Wednesday. If it's 2 o'clock in the afternoon on Wednesday and that deposit has not been delivered, then the seller can absolutely walk. Now, the seller can also waive that right of enforcement. The seller can accept the deposit and move forward. I think the buyer, if they provided it at 2 o'clock after the 48-hour time period, would still be held to the deal, even though they technically violated that piece. But it gives the seller the right to say, I've had enough. You're more than 48 hours. I'm walking. I'm turning to buyer B. So that's what that time is of the essence does. It's dangerous, folks. I think it's great in certain circumstances where there's maybe a level of mistrust or there's cause for concern, but it's dangerous in the sense that especially on the buyer side, if you have to pull dollars from a 401k or some other account that you may not have connectivity to immediately, it really doesn't secure the deal. You have to come up with the money and the seller can walk. Any other questions on this?
Yes, I have a question. Chris West from over Gustav White.
Sure.
In that time frame between when the contract is signed and until you have the money, is that considered an enforceable contract, or does there have to be an exchange of money before the contract is considered enforceable, whether that's the right word or not?
Yeah, no, That's a perfectly good question. And the truth is that if the document, the sales agreement has been signed by buyer and seller and exchanged, delivered, so you have signature and delivery, and the deposit has not been paid, it doesn't matter. The parties have agreed to exchange promises, and that's sufficient, and that is a binding, enforceable agreement. Now, does the deposit time period and the follow-up play into whether the document has continuing enforceability? Absolutely. So if the dollars are not provided thereafter within the time frame identified,
Okay,
then the deal can be terminated. But is there a deal at the time of signature and delivery? Absolutely.
okay, thank you.
Yeah, I want you to also understand something too, about a little bit. I want to kind of accentuate this point about reasonableness. It sounds like a lawyerly word, and it is. Honestly, it's a word that sends us to trial all the time, because what does it mean unless you have a jury of your peers telling you? But if you don't check off time is of the essence, and you simply say that the initial deposit shall be paid and delivered within, let's say, 72 hours, right? So it's within 3 days. And on the 5th day, the deposit hasn't been provided. Can the seller walk? I don't think so. If a seller calls me and says, geez, this buyer didn't step up and follow through, we have a time period here. Isn't that time period meaningful? I would answer, well, yes, it has meaning. It gives structure to the time period, but I don't think 48 hours later is out of bounds. Now, let me contrast that. Let's say another 72 hours goes by. So you had the first 72, no deposit provided, another 72, that seller, I believe, is entitled to walk. Okay, at that point, the seller has been more than reasonable. The time period they identified has been doubled, and it was in the form of hours. They showed an interest in attentiveness, and it's reasonable to say that the buyer should have been attentive to that reasonably that time period. What we have here, folks, though, is it goes to the issue of enforcement, right? And of disputes. And that's the real challenge. And we're going to get into that a little bit later about what happens when you have non-compliance here. How do you get the dollars back, or how do you take the dollars if you're the seller in certain circumstances? So I'll get into that in a little bit. Any other questions about this section 3?
Yeah, Brian, there is a question. The question is a release necessary at that point?
Yeah. So is a release? Well, if you think about it, the deposit hasn't been paid, so there's nothing to release. I guess you're saying that you have a signed agreement, right? And so you're into a contract, and then you had non-performance by the buyer in the way of the deposit provision. Does the seller need to have some kind of release signed by the buyer? Well, my take on it is that would be wonderful, right? It'd be wonderful if the seller could turn to the buyer and say, listen, we all know that you failed to meet that 72-hour or 48-hour time period, and I want belt and suspenders. I want assurance that you're not going to bother me anymore, and that this deal is indeed done so I can turn to buyer B. The truth is, in practice, and you all know this, that the buyer is likely upset that they thought they had a deal. They were tardy with the deposit. I doubt very much the buyer will volitionally sign any kind of release like that. I don't think it's likely. And so try to get it, sure. If time was of the essence, then I think if the seller called me and said, the deal was that time was of the essence with respect to the deposit being provided within 48 hours. It's been 72 hours. I gave him a little bit more time. Can I just walk from this deal? Time is of the essence checked off. I would say, yes, do not worry. You win the day. Okay. If it's a little different, I want to contrast that with time was not of the essence. we had a 48-hour time period. It's the following day. Geez, they're another 24 hours late. They're 24 hours past the time frame that we identified. Is the seller does the seller have the power to just terminate the deal and not be concerned about having dueling buyers? I think the seller should take great pause, should not enter into a different deal. They need to make sure that they've closed out the first deal. My advice would be exercise caution, wait a little bit. Time was not of the essence. And at some point where it becomes, clearly unreasonable, you can move on. What is that time period? It's really factually specific. And I think you need to go to your brokers about it, maybe consult counsel about it. When can that seller turn to the marketplace and get another buyer?
Excuse me, I have a question. So it is essentially up to the seller to check that time is of the essence box when they're returning the agreement to the buyer?
Yeah, so in process, I think that I doubt that a buyer would check off that box because they would, I don't think they want to hold their own feet to the fire. I suspect it will be the sellers who are checking off that box. And I think that the timing associated with that is important. And so let's talk a little bit about these logistics. So let's say the buyer completed the document, right? Signed it, included 48 hours within which the deposit should be provided, but did not check off time is of the essence, right? And the seller looks at it and says, well, wait a minute. I'm not happy with this vagueness surrounding 48 hours. I want a hard deadline. Then the seller would check that off. But when that document flows back to the buyer, that constitutes at that point a counteroffer, right? It doesn't close out the deal because buyer offered these set of terms and conditions. Now the seller has countered with alternative conditions, and it's up to the buyer to say, yes, I'm okay with it. No, I'm not. So yeah, it's important everybody get on the same page. And I think that, again, it's another reason why being perceptive and attentive to the document is really important. So if you're representing a buyer and you write in 72 hours and you get that seller signed document back and that time is of the essence is checked off, you had better do one of two things. You had better alert your buyer that that's the deal if you simply operate that way, or you better go back to the seller and say, this isn't agreed upon. Your counter is not agreed upon. We need to change this. Any other questions? It's a good question.
No, I just have a comment. So to me, this comes into a lot of just communication between the realtors themselves. If you know your buyer is obtaining monies out of a 1031, I mean, not a 1031, but a
401k.
IRA or something like that, or 401, you need to know up front before you're even making the offer to the next person, how long is it going to take for them to obtain this money from the company? If they say 10 days, which I've had it that way, it might be 500 up front and the balance due after the 10 days.
That's right.
Or it really comes down to that, because I am using the time of the essence, but our company also has automatic deposits. So we can do an ETF right from your buyer. I never see their account, but the company does, and it goes directly into the company account. So there should be no reason, unless we've been notified ahead of time, if it's my listing, should be no reason unless the buyer's agent discloses that.
Yep, I agree. I think it's up to that buyer's licensee to have awareness of what their buyer can do in terms of performance. Absolutely. It's a good point. Any other questions on this? Okay, I'm going to move on to escrow.
We got another one.
Yeah, sure.
Brian, I have another question. Yes. So the question is, if the seller counters with time is of the essence, would buyer's initials be necessary to agree to this change?
Yeah, it's a good question. I think, frankly, that so what you're going to have here, actually, if you think through this, if the buyer prepared the document, the buyer would have affirmatively checked off no, right? And so the seller will have I guess, crossed that out and checked yes, and that seller should initial, so that we have clarity of that change being made. And then, yes, do I think that in order to consummate that counteroffer deal, that the buyer should also initial? Absolutely. Yep. Any other questions? Okay, good. Let's go down to the escrow. So the primary change here was a practical one. Again, I think that RIAR has its hand on the marketplace and is simply saying there are instances where the deposit monies are going to lawyers or other parties, and so we want to provide a space within which licensees can fill out who actually is performing escrow services. That's what this is. That's what Section A does. What are the concerns about this? Well, I just think that you need to understand a few things that are distinct from what you've learned about for example, the dollars being given to the general treasurer. So you all know that, and you try to stretch that out sometimes by agreement. But if the deposit's sitting there in this dispute for 180 days, then you have a duty to just submit those monies to the general treasurer. The same is not true for a lawyer. I don't have to do that. And so I'm not a licensee, right? And so I don't play by those rules. And so that's one distinction. But the thing that is the same, which is the most critical, is Section B, really, and Section C. I mean, all deposits shall be applied to the purchase price unless mutually agreed in writing. In other words, escrow agent, don't you dare move those dollars anywhere, no matter who you are, lawyer, broker, otherwise, unless there's mutual agreement or a closing, right? And then it goes to release of deposits in Section C. And then I just want to make a point about this. I wrote seller has leverage, and you hear about that a lot. The truth is that let's say we had a financing contingency, and the buyer comes back and says, I'm sorry, I don't qualify, and I couldn't get a commitment within the time period. As the agreement says, I just want my dollars back. And we have sellers that are frustrated and they drag their feet, or they just outright refuse to cooperate. And there's a reason why the old phrase possession is 9/10 of the law, because the buyer at that point is dispossessed of the dollars. The seller doesn't have them, but the seller is effectively leveraging that buyer. And it's not nice, but I can tell you that the process for rescuing the buyer's money is slow. That's my next point, right? It's slow justice, just the truth. I often, in connection with litigation, I hear from clients say, when are we going to court, right? It's as if we file suit and somehow the court just sets a date within days or weeks and we just go to court. Well, that's not how the process works. It's a very formal and prepared process where there's an exchange of discovery, and there are various court meetings about process, about evidence. And so slow justice, some people say slow justice is no justice. And I just want you to know that that's the truth. And so what does that mean for you in practice? It just means really when your buyers are submitting money in connection with a deal, they're parting with that control. If they are in the right, if they really, if Anthony promised Anthony provided a denial, right, of the mortgage, and the buyer is rightfully saying, I did not get a commitment within the time period provided, I want my money back. You still need a judge to bang the gavel. And so that's the challenge, is getting to that stage. It's not exactly expedited. And then the last thing is it can be expensive, right? So I always, in connection with my commercial deals, I represent a lot of developers and other parties like that. And so I can manipulate the document. And one of the things I always do is I insert an attorney's fee provision, right? Because in the event that the other party's a bad person, and in that example I just gave, Anthony Amaral and Wash Trust said, hey, we can't write this loan. We can't underwrite it, denied. And the buyer says, I can't get that commitment. I was denied. How unfair for the seller to hang that money up. And so if you have an attorney's fee provision, if you win that case, the court is empowered and frankly motivated to not only say that the buyer wins, but potentially to shift attorney's fees. It's called fee shifting. It's not the American system. The American system without an attorney's fee provision is, hey, parties to the lawsuit, you take care of your own attorneys, take care of your own fees. We don't play that game as the court. You're just two litigants and we're going to treat you equally. And that fairness factor plays, and you say, geez, how could that be? If it costs $10,000 in legal fees to get a $10,000 deposit back, that's not very fair. And in that sense, the system is not fair. And so that's why I think the omission of an attorney's fee provision in your default section is something that maybe RIAR should consider going forward. It's something that we can put in section 19 for them to think about. Because I have to tell you, when I argue with, hopefully I don't argue with, but I communicate with other attorneys about this in connection with like commercial deals, I say to them, I ask the question, why is it a problem for us to have the court authorized to award attorney's fees to the winner? Does your client intend to breach? Is that the intention? Because if your client doesn't intend to breach, then they'll have no problem. They'll never pay attorney's fees. Mine certainly don't. But if ultimately we have a breach and someone, acts in an unjust way, then I think it's perfectly appropriate to compensate them so that they're not out of pocket. So that's my 2 cents on that. Any questions on section 4?
Yes, one thing. So could the seller in that time frame still sell the property?
Yes. So again, I think they're in the position of the deposit not being provided with, in the lack of a time is of the essence situation. I think that the seller would have to probably speak to counsel, certainly at least a broker owner, about what transpired and whether the buyer, had a basis for clinging to the deal. It sounds like you're thinking more along that lines, like maybe the buyer defaulted or something, or whatever the situation. Put another way. I don't think
I
the
know
deposit.
I just know one of the girls in the office had a situation where, sort of like what you're saying, I don't think it was time was of the essence, but it came down to monies or whatever in the deposit not being done. And then again, when you get farther down, but then the buyer who was not following through and was totally past all deadlines and everything that you'd think were not reasonable, like you've said, they weren't waiting a day, they waited over a week, 2 weeks. The buyer went down and recorded the contract so that the seller could not sell it to another person, even though they were already in contract with another person, because they weren't even getting back to them. Yeah. So there's so many different scenarios. That's probably not as common.
Yeah, let me speak to both. Both are interesting. So the first one is just the decision of a seller to turn to another buyer. I think, my advice always to sellers in that position is we have to be really comfortable and confident that the first deal is done. Because to the extent that it has any life, then it's very dangerous to promise buyer 2, that we can sell to them. Right now we have 2 deals going, bad situation. So that's number 1. And number 2, with respect to the recording of instruments, again, this is the buyer acting in a dirty way, basically to what's called slander the title, right? And so there are there are several legal theories that the seller could pursue against the buyer for doing that. Certainly breach of the agreement, the underlying agreement. And then you have the act of recording the document in the land evidence records, which is a slander of title, generally speaking. You have to show a level of maliciousness. And so it really goes to the core of the buyer's right in the property. If the buyer knows or should know that they've truly defaulted, it's really dirty and malicious. I think the closer the call is, the less likely that a seller would prevail on a slander of title. And then the other theory, I mean, I'm just rattling these theories off, is tortious interference with contractual relations. That's another theory where you say, you bad first buyer, you know I have a new deal and you're attempting to disrupt it. How dare you? And you have no justification for that. And so you pursue the first buyer on that front. But I think the number one takeaway here is be careful with that seller pursuing another buyer. You need to have comfort and closure on the first deal. You don't want to complicate an already complicated situation.
Ryan, I have a question.
Sure.
Is the provisional legal fees paid by buyer/seller or taken out of the escrow funds?
Yeah, so all legal fees. So if someone walks into my office and says that they're a party to a deal and, you know, it's gone bad, but geez, LaPlante, I've got 50 grand in deposit money sitting with the general treasurer. Don't worry about it. My response is, I am worried about it. I have kids to feed and I need you to give me 10,000 or whatever my retainer is. And that person, that's the pain. That's the last bullet point, the expensive justice. They have to come out of pocket to chase what they deem to be theirs. And so the attorney's fees are not paid by the deposit or the government or anyone else. They have to fund that process. So that's often the challenge. Any other questions on this section? Okay, let's move. So now we'll go to closing date in place. So the first thing that RIAR did is they logically ordered this. You know, closing used to be above the escrow, and so I think that made a lot of sense, right? You got the deposit section, then you got the, you know, the purchase price, then you have the escrow process, and then you've got the closing date. And so, you know, I just remark that they still use the closing verbiage that the closing will be at the land evidence records. Well, not only is that, you know, not happening now with COVID, but it's also just uncommon in Rhode Island. I mean, in Massachusetts, it's very common for them to record at what they call their registry of deeds. But typically it happens in the buyer's or lender's counsel's office. Again, not a big deal. It's just interesting. I think the reason they do that is it's a placeholder, because there isn't clarity before the parties enter into the deal where it will be closed. So it's a reasonable placeholder. Hey, if we can't agree on something different, meet you at the land evidence records. Now, I wonder what that means right now, because we can barely record documents, never mind meet there, but in any event, that's what it says. And the last thing is this issue of gap coverage. And so some of you know what that is, and I want to explain it to you. So basically the issue that confronts lawyers, if I'm doing a closing and the parties to the deal they're just wonderful. The seller came with their deed and they signed all the seller documents, and the buyer gave me all the money. They did it 2 days in advance. I'm fully funded. The dollars are live. Isn't this wonderful? Well, here's the problem, right? The problem is that when I go to, so let me back up. I am not fully comfortable with what the seller did unless and until I record the seller's deed. And I look at the title all the way up to the time of recording, because that seller could have done something inappropriate, right? Before they came to my office, they might have gone to Centerville Bank or somewhere and signed a mortgage. and it was recorded before me. They could have done that, right? Maybe they didn't pay a bill and they got an execution entered against them and it was recorded that morning before I go there. So these are called what we call intervening liens and encumbrances. I checked the land evidence records for this closing 20 days ago. Everything looked clean. There was one mortgage payoff. Pay Anthony Amaral and Wash Trust. Well, not Anthony, he doesn't get that money, but pay Wash Trust, $150K. So I think everything's wonderful. Now, typically, not in a COVID environment, I send an examiner out there. They have the deed ready to record. Everything's wonderful. They do what's called a rundown. They run down the title through the moment that they're about to record to make sure nothing funky happened since the last exam. And they're, 99 times out of 100, everything's fine. The problem now is we can't do that. So title updates are challenging. The recordings are delayed too. So the best we can do basically is we can bring that seller's deed and put it in a box typically, right? That one of the clerks comes and they rescue, they take it and they put it on record. And so what if the Centerville mortgage was lower in the box below us? We can't really see it, right? What if the box was cleaned out earlier that day and the Centerville Bank mortgage was recorded and we just don't know it? And so the other thing that we try to do is we try to update our analysis of title through the online system. It's excellent. Most cities and towns have it. Even in my dear Situate, we're online now. Hallelujah. But the issue there is there's still delay, right? Recordings are delayed. They're not instantaneous everywhere. And so after the closing, I go online, everything looks wonderful. And I go out to Situate, I drop the seller's deed in the box and wow, I feel comfortable. Unbeknownst to me, there was the Centerville Bank mortgage recorded earlier that day. It didn't show up on my online review. I couldn't see it in the box there. And so I have trouble. So what we have there is gap. We have a gap in time. And so the title insurance companies say, I understand the problem, closing lawyers and sellers and buyers. And so what I'm going to do is I'm going to afford you gap coverage so that if there's any intervening lien, buyer, right? So the buyer's paying $500K for the property and they learn about, oh my God, this bad seller recorded $150,000 Centerville Bank mortgage this morning and it wasn't paid off. Where's my 500 grand? Well, the good news is that the title company says to the buyer, don't worry about it. We'll take care of it. We're giving you gap insurance coverage, right? And the only protection really that the title insurance company has is they turn back to the seller and say, naughty seller, I want indemnification. And so you're seeing this at these closings now, more and more, gap indemnification by the seller. And basically what the document says is, seller, we're going to have a time period where we can't know what exists as a matter of record, and you better not do anything wrong voluntarily. And if someone files a lien against you, and maybe you didn't even know it, maybe you're innocent, if you owe the dollars, and if someone enters an execution on record for $15,000 because you didn't pay your contractor, then you're going to own it, seller. So the title company's putting themselves at risk. They have some rights against the seller, and really, overwhelmingly, this goes smoothly. Any questions about this?
Yes, is somebody paying for that gap insurance? Who's covering that?
That's a wonderful question. I am waiting. I can't believe that the title insurance companies don't charge for that. That even if they charge 50 cents a deal, that somehow they build up a reserve, because that's often what they do. You've heard of survey deletion fee. Like they have all these little fees that they've developed over time for that once in, 1,000 chance of being adversely affected. And so, but they don't right now. I think it's just built into their rates.
Okay, thanks.
Any other questions about 5? Okay, we'll wrap up shortly. We don't have much longer. I appreciate everybody paying attention. All right, section 7 is the mortgage contingency. A few changes. This section has gone through lots of iterations. Really what changed here is in section B, there's reference to the buyer shall make diligent efforts to apply for a mortgage. Well, that's wonderful, but the truth is that there's little transparency here. I think it's a good sentence to include, right? It certainly doesn't hurt to tell the buyer, do your job, act in good faith, and to say it expressly. But it's all about enforcement, and so it's very challenging to enforce. I'm going to explain why. But buyer shall make formal application, within X days of the date of this agreement. That's a good thing. So now we have some kind of standard there. But if the buyer submits an application to Anthony, and then Anthony's, underwriter asks for a list of documents and information, and they don't follow up, how do we really know if they've been diligent, right? Isn't that that's really the question? And there's really not an answer to it. I think because of the sensitivity now to private, information, private financial information, there's more of a lockdown on the transparency concerning that process vis-a-vis the seller. And so I think because of that, sizing up the buyer, if you're representing a seller, is really important, because and it's hard. Because there are limitations to which you can go. But I think you have to exercise some common sense about whether the buyer appears to be capable of consummating the deal. You don't want to tie up your seller's property for something that ultimately won't be closed. And so frankly speak, you just have to do your best. There's no, I don't have any magic. Just do your best. You be perceptive, listen, watch, follow through. How's everything going with the financing? Just because this document provides for processes doesn't mean you can't ask as a licensee, another licensee, hey, how's it going? In terms of the seller's right to investigate, basically they have a right to a status from the lender, right? That's basically it. To confirm, if you see right here in section B, buyer authorizes seller, right? And or, bear with me one sec. It's actually, yeah, it's to confirm any, to contact any such lender to confirm the status of buyer's application. That's a curious word, status. Pretty much that tells me it's in process, it's denied, or it's approved. I guess that's it. And then it includes the word including denial. So I guess you can put your hand on the pulse. Can you ask the lender, has the buyer been cooperating? Has the buyer provided the W-2s? No, and I don't think that lender would provide that information anyway. I think it's a generic status. It's intentionally generic. And so, there's a limit there. And then the other thing that happened with the most recent changes, the removal of the buyer's requirement to provide a denial letter, right? Now it's just reporting. The buyer reports to the seller, yeah, I gave it the old college try. I was denied. I was diligent, but I was denied. And it doesn't really sit well with sellers because they're curious, did someone know Anthony and he just gave that denial, or was there an inside deal? And I think we all have had experience with that. And again, I think it's a matter, it's kind of like anything with this business, is you just try to find good people who seem trustworthy, and you try to perceive all you can about their trustworthiness. Any questions on this?
I have one. So if they're denied, does it have to be before the contingency date for them to be eligible to get their deposit back?
Absolutely. Absolutely. Yeah. Yeah. you've got this mortgage contingency deadline, and if it's not respected, then they have an obligation to move forward, to close. Right? And so they're in a bad spot. That buyer who didn't respect the mortgage contingency deadline is in a bad spot. You have to be very careful with your buyers in the sense that if you approach that mortgage contingency deadline, you need to ask for an extension or you need to provide a denial. One or the other, if you don't have that approval. Go ahead, Mike.
Question, do you have to provide an approval letter by the deadline, by the buyer's agent?
An approval letter, an affirmative approval letter?
Correct.
No.
If it goes by that date, you would just assume it's approved?
So the date is exhausted, you move beyond it,
Yeah.
and you're sitting there as a seller wondering.
Right.
Right. All right. So basically what it says here is, if buyer fails to purchase, let me just try to find that particular phrase. Yeah, I mean, I think that's where that would fall, Mike, is that buyer's locked at that point. Yeah.
So if I can ask a question, it is common on the commitment date that the co-broker will ask you for your borrower's commitment, which I feel is not necessary and also is kind of infringing on their privacy, because the sellers don't need to know, what their explanation of a car loan or whatever personal details. So we don't have to provide the commitment. But what you're also saying is we don't necessarily have to provide the denial. We can verbally or perhaps via email or something in writing tell them that we have the denial, but we don't have to actually give the information from the lender.
It's exactly what section 7C2, Roman 2 says, that with respect to that denial, you no longer have to provide a copy of that written denial. It says that the buyer has to have received a written denial, but the communication back to the other licensee is, we've been denied, buyer's denied, and so we're out. Well, show me proof of that. You need not do so under this agreement.
I'll just say, I can imagine this is where sellers would say, well, fine, when they provide it, I'll sign the release. If they provided it in the right time and they really did have a denial, there's no reason for not providing it, even if it can be an obscure one, just saying they were denied for financial reasons. We don't have to know why, but
Yeah.
I can see where sellers would hold off on signing the release until they had.
But I'm telling you, that's a losing case. If you hold my buyer's deposit like that, I will win that case. I'll win that case 10 times out of 10 with this language. Now,
Correct.
Can I wait that process out? Can I afford that process? No, it's a different story, but I think that it's up to licensees to explain that to sellers. Hey, listen, this is how it's written. And, we took a shot with this buyer and they've communicated the denial. They don't have an obligation to provide the writing. That's enough.
That also goes into some agents, I haven't done this, but are using forms that they send to, obviously, your Mr. Anthony Amaral sitting there. I'm waiting. I got the smile. I can see him online. So saying, did you sit with the buyer? Did you get their 1099s? Did you already have these things when you pre-qualified your buyer? Not knowing what they mean or represent, but there are realtors out there who actually make that part of the offer form. And they're saying it's the seller is requesting this to make sure when offers are coming in at this stage, that they know they're a truly pre-qualified person. And yes, they could still get denied, but then they're asking these finance people to sign off on these things.
Yeah, and I have to tell you, if you write different language into the deal, either at that offer stage or even into this P&S, then it's applicable. As written on the form, it's not. They can't delve into that. They could call the lender and say, the buyer just communicated that they've been denied. Is that true? That can happen under Section B. Buyer authorizes the seller or listing licensee to contact the lender to confirm the status, including denials. That's the move. It's not the writing. And I have to tell you, it almost puts more pressure on that lender, you know, in that situation. You almost get better information than a stale one-line denial. You can maybe read into it, but.
Brian, we do have some questions, but I think that we should get through the other sections, and then if you have time and those that want to hang on for the answer to answer some of these questions that are in the chat, we can go that way. Does that work for you?
Yeah, that's fine, because this last it's one more section and we're done. So the last section, they made some changes to is Section 10. And the other sections, Linda, were really formatting.
Right.
They weren't substantive, and that's why I
Okay.
didn't include it. Yeah.
Okay.
So yeah, so Section 10, basically, you know, instead of using the word towns, which was incorrect because there are cities in the state, they use the word municipalities. Nice job cleaning it up. I like it. I respect it as a lawyer. They removed the initialing required in connection with Section C, the assessments, right? And I think they did that likely due to disputes when it was left blank, when the parties hadn't initialed. Geez, I didn't agree to that. And so this is a way of just letting this document flow in a similar fashion as that time is of the essence checkoff. And I think this is important. I always dig into this on any kind of deal. I want to know as a seller or a buyer, and I think my clients want to know, is there an assessment applicable to the property? A lot of buyers are surprised to learn that there's a $14,000 sewer assessment out there for which they'll owe, $1,200 for the next several years. And sellers, they surprised if the seller shows the balance, right? They're expecting to earn X dollars at closing, and they see the payoff of a sewer assessment of $12,000. That's surprising to them. I think it's important that you as licensees bring home those 2 points. The first threshold question, though, is there an applicable assessment? Because that conversation might be needless if there's not. I'm here to answer any other questions if anybody has any.
So Brian, I'm going to ask these chat questions. So going back to the previous section, does the lender have you might have already answered this, does the lender have the ability to reveal status as approved or denied to the seller?
Yes.
And then,
Linda, hold on. If I can add
okay.
to that, just one caveat to that. You do per the letter. However, it is a lender cannot give credit decision information directly to third parties, even if the purchase and sales represents it. So there was another question earlier about asking certain documentations have been received. We can't give that information. If someone is giving it to you, they're doing it illegally. At that point, I cannot physically give any set information which would lead you to understanding that person's financials, income, assets, or any other characteristic of it, including a credit decision, which is a denial or approval. Those are, and even on a credit decision, even on a conditional approval that's done by an underwriter, I generally don't send those to Realtor.
Well, that's interesting. That was Anthony saying that?
Correct.
Yeah, that's an interesting issue because right here in the agreement, there's the expectation that the seller or the listing licensee can contact the lender and say, please tell me the status of buyer's application. And I assume again that those categories are it's pending, it's approved, it's denied. I agree with you that delving into the details surrounding that is out of bounds, no question about it. I think it's interesting if the privacy law and related laws are such that you would feel even uncomfortable saying denied or approved. It's been denied or it's been approved. I mean, that's contrary to the very intent of this language. And I'm surprised there'd be that disconnect between your financial world reality and what RIAR put in here. So, but it's something for everybody to know that practically speaking, you can't force that third party, that lender, to do so.
Correct. And as so just for clerical information, I spent 15 years in the mortgage.
Anthony, come closer.
Oh, I'm sorry. Is it not working well? I spent 15 years as a mortgage underwriter before I got into lending on the origination side itself. So that is a standard. We take classes on a yearly basis for our NMLS numbers, and that's actually written in there. It's actually a question that came up recently because I had to take them again as transferring over to another company. But it states that personal information of any nature cannot be transferred over. You can, however, share it with the consumer, and that consumer is free to share it with whoever they want, including their lender or others. And I guarantee you, and I've seen it several times, there are lenders out there or loan officers who are not aware of that condition and do share that information, but it is, they can lose their license directly. It is, there are, we just like realtors have to take classes on well, I think you have continuing education every 2-year requirement, but we have to do it every year for how much we can physically lose our licenses.
If the buyer requests you to give information to the realtor.
So,
because if they sign off on that, because I have a lot of clients who don't understand a lot of the verbiage or anything else, and I'll let them know, please talk to your attorney, have them talk to me, I can explain it. Please talk to your mortgage person, I can explain it.
That's right.
Because sometimes it's just in the verbiage isn't just down to earth for a lot of people to understand it.
We had a court study a few weeks ago. I think the biggest issue overall is the difference between pre-qualifications and pre-approval letters. With this current industry of being able to go to a Rocket Mortgage, say, enter in some information, spit out a pre-qualification. We have several lenders, several brokers who do call us and ask us the questions where did you view financials? Did you view specifically asking, did you use pay stubs? Did you view W-2s? If I do that, I'm giving you information about their overall. So my general reply to most of those are about how a personal conversation with them. All required documentation in order to verify that they can sufficiently support the mortgage they're applying for before the loan has even been submitted. So it usually covers it in that conversation that I have. It may require some additional conversation, but in the end, it still comes down to the consumer. Even though maybe something they might ask the question for, they don't understand. I might have a 3-way conversation directly with them, but it's really, I can't personally share that even on the ask of the customer, of the buyer.
And then lastly, Brian and Anthony, there may not be legal questions or answers to these questions, but if maybe you could just touch upon it. How many days should a buyer make a formal application for a mortgage? And how many days for a buyer to authorize a lender to order an appraisal? What is an appropriate number of days? And I guess that, those are some of those blanks that are on the PNS, Brian?
I'll defer to Anthony. I think it's important for that buyer to communicate with their targeted lender to get that feedback. But Anthony, what would you say generally?
So the difference between a pre-qualification for anybody and a loan is an address in a contract. Once every customer, especially in this market, is already going to a pre-qual status, having a letter in order for them to even view properties. So they've already started that, and it usually lasts between 45 and 90 days. The reason why that pre-qual is that, from that standpoint, because in the first 45 days, you want to verify there's no changes directly to their income, especially in the last year with COVID. Their income or their asset or their credit, to see if they got any new debts that might change their debt to income ratios. The 90 days requires it because then once that hits that point, so 45 and 45, at 90 days, the credit's expired. So we have to re-pull credit in order to reevaluate that. That's the plan. We'll do that and then reissue a new pre-qualification. If you go out and look over a house and go under contract, the moment that last piece of information, which is the address for that property, is received, that becomes a full-fledged application. It needs to be submitted. And we have regulations which state that once it becomes a full application, disclosures have to be sent out within 3 business days from that time. So we're heavily regulated in that time frame from when we start to finish and receive it. Now, if I'm not notified that somebody took a purchase and sales over the weekend, or the deposit has been made or signed, fully signed, now, mind you, it's fully signed, sellers and buyers, purchase and sales agreement. So an offer is one thing. An actual signed purchase and sales agreement makes it a valid contract between the 2 parties, and therefore that property addresses the property address they're buying. So that's the official date. It's a little bit more delayed right now because of the time frame that an underwriter might review a file. I mean, disclosures go out, appraisal and title are ordered usually within the first 5 days, assuming all disclosures are signed within that time frame. After that, it's usually about 2 weeks almost for an underwriter to look at a file, just because because that's how inundated everybody is with based upon the refinance boom we had in the last year. But the purchase and sales agreements have precedent over the rest of it because they have contingency dates that we're trying to meet. And we'll type those in the system, and a lender will specifically look at that contingency date in order to try to get it to that time frame, even before, if possible. But we're always shooting for those dates.
So Anthony, what do you think is reasonable? Is it a 30-day period? Is it a 45 for a mortgage contingency?
Well, if a contingency is, it's 15 to 20 days for a mortgage contingency for most parts. If you're doing something along the lines of Rhode Island housing, you might want to look for a longer period of time. They're more inundated than most. They don't pick up a lot of staffing over the last season. They're still doing a lot of refinances as well with their existing market base.
So that's the practical point. But I guess from the buyer's perspective and the licensee's perspective, you want to submit an attractive offer, right? And so if you say, geez, I'm really going to need 45 days, it becomes less attractive than someone else.
Yes, you're absolutely right. Just like any others that right now, it's really interesting to see those come across with no Hubbard clauses directly on it. It becomes more warrantable, more streamlined process across anybody who doesn't need mortgage financing. It's just cash, you're going to get first consideration. That's just the market that we're currently. Linda, you're muted.
Yeah, I think we've covered it all. Brian, I have no more questions in the chat, and want to thank everybody for attending today. Brian, thank you so much for providing this information. Everyone, I think, away something.
I appreciate everybody's participation. That was great. I learned a lot from all of you, and I look forward to doing it again. Thank you, Linda.
Thanks, Brian. Thanks, everybody.
Everybody,
Take care.
A reminder too, tomorrow we have a class as well. We don't only have 2 in a month, but both of these topic studies were very fantastic to present. So we have the millennial consumer tomorrow, starting at 11:30. It's how millennials differ from the buyers and sellers of other generations. It's a very good class to attend if you're available. And as always, Ken Washington Association Committee, Education Committee is always looking for new ideas and also other representation as well.
Anthony, I'm going to end the meeting, except for if you would just stay on, please. Thank you.
Take care, everyone.
Thank you very much. Have a good day.